Long night at the State House.
The Dan York State of Mind program is brought to you in part by Lookout Rhode Island and Taco Comfort Solutions.
So while the Senate last night pounded its chest over being active until 6 o'clock in the morning, yeah, like anything that anyone was paying attention to anybody at 4:30 in the morning last night, this is something that drives me crazy. The time management skills of our General Assembly and the way they go about their business sometimes is just, well, we'll talk about it. I have a feeling my guest will probably challenge me on that, even though he's in a different house. Although I thought he did a good job asking some really conscientious questions last night at the House Judiciary Committee, which took a look at this abortion bill and passed it by a vote of 9-7. Welcome in. Nice to have you on this Ash Wednesday, the beginning of Lent. You know, it's 28 degrees out and the snow is piled high, and after 40 days, it'll be Easter, and it'll be spring, and we will be renewed, and it's a good season. The White House is ready to fight. Oh, gee, what a concept. It looks like with 81 letters that have been issued by House Oversight, the White House is saying, you know what? We don't think so. They're being recommended by many to just ignore the letters, which could force subpoenas by House Oversight, which could force the White House to say no, which could force a court battle. And so it is on right now with Democrats in the House and the Republican White House, of course. And I am not, I'm not certain how this whole thing is going to bear out, but it's a full court press by the House, but a full court defense already by the White House. Meanwhile, Quinnipiac poll is really interesting. Nearly 2/3 of voters think that Trump is a criminal. But nearly that many don't want to see an impeachment process. Crimes before office, depending on whether they were in the campaign or not, most folks are not there yet, which is really fascinating. The psychology of America right now is something that will be studied in history for a long, long time, because certainly it has not yet been written. By the way, most people in the Quinnipiac poll believe Michael Cohen by a large margin over the stories that Donald Trump is telling. Yet discipline by the constituents on impeachment continues to be in place, which makes sense in a lot of ways because the Mueller investigation has not yet been made public. I wonder what the hue and cry will be if it never does become public. Headline last night for the coverage: Rhode Island House panel okays abortion rights bill. Here is Eyewitness News coverage.
The House Judiciary Committee makes a historic vote Tuesday, passing a bill on abortion rights.
This is a bill that is constitutional and will last the test of time.
Chairman Robert Craven voted in favor of the legislation that would guarantee the right to an abortion in Rhode Island should things change in the Supreme Court.
This is an insurance policy in the event that the Supreme Court overturns Roe versus Wade.
I'll be voting no on this bill and urging the members of this committee to vote no passage this evening.
The split vote came after a debate. Representative Chris Malaya voted no, telling the committee he believes the bill goes beyond Roe versus Wade.
The problem I have with the current bill in its current form is the word health.
I think they were well defined by the United States Supreme Court because that's exactly the words that the U.S. Supreme Court used in 1973 in Roe versus Wade.
Meanwhile, the debate continues in the Senate Judiciary Committee. More than 100 people signed up to testify.
Respect life. You know, life is precious. I'm here tonight on behalf of the unborn. I ask that you vote this abortion bill down.
It is critical to codify reproductive health care rights into state law.
Fascinating. The minority leader is here, who I thought was eloquent in his questions yesterday about the process, picking in on the entire deal. What's your executive summary of what happened yesterday?
I feel there's a rush to get this issue through, and I think there's problems with this bill, and in many respects it far exceeds the rights that are codified in federal law.
I'm not sure. There's some nuances to some things that have been torn down, and I think you made some really good points yesterday about some things that are outside the acute language in this codification bill, namely this quick child legislation that is on the books right now, which would define 2 lives that have been assaulted or taken with a pregnant woman who is hurt by somebody with a viable pregnancy, known in our legislative words as a quick child, which means that there is a viability of heartbeat, undetectable, and the like. There's no actual week named in the legislation. In other words, there's no 16, 20, 26 week type of thing. That's being removed.
Correct.
In this whole package of legislation. So we should talk about some of that. And I'm guessing that's what you're saying when you talk about far-reaching. And I share your concern. But let's talk about the acute language. It seems that this is really all about the addition of the word health on top of life of mother. And that is the language that really has everybody all aflutter. And I think there's been a false notion. By the way, I would have voted no as well, just so you know where I am. But I think the pro-life movement has done a disservice to this argument by hyperbolizing that which they have fantasized about happening in the 3rd trimester. So let's have a reasonable conversation about this. When you say there's an expansion, what is the expansion?
So the advocates are saying that we're simply codifying your rights under federal law.
And we should remind everybody, in case everyone's not paying attention, about why we're doing that. And then, my bad, we should have done that at the top. There is a concern from state to state that with the conservative bent of the Supreme Court, U.S. Supreme Court, that they could at one juncture turn Roe v. Wade over.
Correct.
I think that's a complete reach. Donald Trump has no philosophy on this. Those judges are going to take a look at precedent. They argue a lot about precedent. I think they're going to protect precedent. So I don't think this thing is worrisome as the pro-choice movement in this country tries to make it to be. Do you have a thought on that?
And I also think the court will protect us from societal upheaval. And a decision striking down Roe v. Wade, I think, would cause that. So may there be a ratcheting back over a long amount of time by the Supreme Court? Potentially. I don't see a decision that just strikes down this right that's been on the books for approximately 40 years.
Well, that's interesting. That's a temperament. That's a temperament calculation on the part of the Supreme Court rather than a strict constructionist review of and precedent protection. I've never thought about that. I do think you're correct that the country would go nuts over this.
To say that judges don't think of the practical effects of their decisions, I think, makes us say they're not human. These are humans, they wear black robes, and they have to understand the implications of what they do.
Okay. Point we'll put aside, but an interesting one. Nonetheless, states are rushing, and Rhode Island is at warp speed trying to get this language that we have, which is perceived to be outdated, to match that of Roe v. Wade, because if Roe v. Wade is turned over, it most likely will be discharged to the states to make their own decisions, and that's why there's this thing. You feel like there's a rush.
Correct.
And what bothers you about the rush?
I just don't think you should be rushing legislation through, period. I just don't think you should, especially something that's as important as this.
What is the ample time that you think is necessary?
Well, this was scheduled on Friday. There wasn't much conversation amongst people in the House about it being scheduled. It was a surprise to many people that it was scheduled. And it was scheduled on Friday for a committee vote yesterday, and now it's being debated on the floor tomorrow.
You've had testimony in the House already.
Yes.
When did that happen? A couple of weeks ago?
Probably a month ago.
Okay. Well, we all complain all the time about things waiting to the end of the session. So, right? So, what's the...
I understand. Just because we complain over here about this extreme, about everything being backloaded, doesn't mean we should, embrace the other extreme, which is that, things need to be rushed through in a week. We don't have to schedule a House floor vote for tomorrow, even though it passed the committee yesterday. We have time to wait. We have time for people to really dig into the Sub-A. We have time for constituents to
Sub-A
communicate
meaning
more.
the changes in the original bill.
Yeah, this amended bill, which was presented last night. It was given to us on Friday under our new House rules, but it was presented at the committee last night, adopted, and passed by the committee. We don't have to have a floor vote on this tomorrow.
I think I know why they're doing this. Did anybody tell you? You're the minority leader. Did they tell you why?
No.
Did the speaker tell you why?
No one explained to me the rush.
I think the rush is just the natural. I don't want to deal with this anymore.
Potentially.
People it was just like, can we just get this thing done?
I think
that's what it is.
There needs to be more digesting of this. The people who live in this state need to digest it. They need to reach out to their representatives. There's significant changes in this Sub-A from Rep. Williams' original bill. And I think these have enormous implications for pregnancy and specifically the quick child statute and fetal homicide in our state. The original Williams bill did not strike the fetal homicide statute. This one strikes the fetal homicide statute. And for me, I think this is the most glaring example of how we are going beyond federal law.
Okay, we'll talk about that when we come back. We'll dig in when we come back. Stay with us.
Honestly, what I think we're doing is a good thing. I think we're making it clear what can be done, but as I have seen the arguments from both sides, we're making it clear what can't be done. Late term.
That is Bob Craven, who may appear with us tomorrow. We're still looking for Democrats to defend this bill this week, and we'll hopefully have that tomorrow. But Representative Filippi is here. You were actually in the middle of a conversation with him when he was talking about that. Let's go on the main frame of the legislation change that we began the conversation with, and then we'll talk about these other things that you say are the reach. You think the addition of the word health is also a reach?
I think an undefined addition of the word health is problematic, as well as an undefined necessity. And we're talking about late-term abortions in this conversation.
Now, what Craven is saying is, listen, abortions are not legal unless a doctor suggests that the life and the health of the mother are at stake.
In that third trimester abortions.
In third trimester abortions. What he's saying is, well, there's the protection. That's the protection. We've had the protection for life, we just haven't had the protection for health.
So, when you look at Roe v. Wade, it uses language, life, health, but subsequent cases, specifically the Gonzalez case, which dealt with the federal partial birth abortion ban, and the partial birth abortion ban specifically said the life of the mother. And there's nothing in Roe v. Wade that means we can't define what necessary is, what health is. It's a broad decision, and I think it's our duty as legislators to interpret it and say, okay, what is health? Is it mental health? Is it severe problems of mental health? Is necessity meaning that it's the only option, or are there other options? I don't think Roe v. Wade restricts our ability to say, okay, what is necessary? What is health?
This is fascinating, because although I'd vote no on the legislation because I'm pro-life oriented, and that's a whole different sticky wicket. I don't find your argument to be incredibly compelling. I don't know that we want, and I say that respectfully, I don't know that we want to be sitting here trying to define health. What they're doing is saying, listen, a doctor is going to make a reasonable decision about what life and health is, and you got to live with it.
And so just to play that argument out, the doctor who is going to be making that decision is the doctor who is performing the abortion, likely. And we've taken...
There's a financial interest in it.
And so I think our lack of definitions creates a gray area. The person operating in that gray area is going to be the abortion doctor. And we've also ratcheted back the penalties for violating our statutes. So it's...
In this package.
In this package. So right now it's a felony. We're going to be pulling it back, so if someone violates the statute, it's a professional conduct issue on the doctor's license with the potential of criminal implications which don't exceed a misdemeanor. So it's the combination of those three. It's the vagueness,
and previously we've had stiffer penalties.
Felonious. It's been felonies. So it's the combination of, I think, a vague standard with the person interpreting that standard being the doctor who wants to perform the abortion, coupled with, I feel, light penalties for violating
Yeah,
the
I'll tell you,
statute.
it's interesting, because an orthopedic guy or a gal who takes a look at your knee and says, well, that's worth 15 grand right there, but knows that a little PT would go a long way and maybe surgery's not necessary. That Hippocratic oath is supposed to guide that decision away from the cash cow $15,000 operation. I would hope the same is the case with the gynecological world.
Well, I'm not saying there's a pecuniary interest or financial interest for the doctor. They may be morally opposed to any state restrictions. I'm not saying it's for the money. It could be philosophically they disagree with any restrictions, and so they will liberally interpret necessary for the health of the mother. And listen, you're a pro-life guy. I don't even consider myself pro-life. I consider myself pro-privacy, and in the first trimester, I think you have the unlimited right to do whatever the heck you want without government interference. So I'm not someone who's far on the right.
Which is really interesting. I think the one thing I've noticed for the first time is that we've had some very thoughtful conversation about this from all directions. I had a radio show yesterday which was phenomenal with people who were coming at it from all sorts of discussions. I thought your temperament in House Judicial yesterday was outstanding. I think there's a lot of good thinking going on here, and there are people who are walking in other folks' shoes. I didn't get a lot of that typical shelf argument, the argument on pro-life, pro-choice, which just makes people go, ah! Yeah. Because there are a lot of nuances to this whole thing. So,
it's a role of government analysis, and that's what I think the Roe v. Wade decision at its core was a role of government and our private lives. And they said, in the beginning, your privacy trumps the government interest. But towards the end, the government has an interest that can trump your privacy. And I think that's what many of us policymakers are grappling with.
Right. When we come back, some of the extra stuff that bothers the minority leader. Stay with us.
Health is health. And whether it's a mental illness or a physical illness, something that is going to impact the mother's health is something that should be respected by the medical care providers.
That was part of a conversation you also had. That's Dan McKiernan, the Democratic state rep. Some of this expansion concept that you're articulating is rooted in some of the stuff that's been taken off the books, specifically on the definition of the fetus in the context of an assault. You characterize this as what? The
fetal homicide statute.
Fetal homicide statute.
And that's what these statutes are commonly known
as. Right, and explain what we have now and what this is proposed to do.
So we have essentially two separate fetal homicide statutes. One was found unconstitutional because it included doctors and mothers that seek out an abortion, and that was pre-viability. The post-viability quick child statute includes doctors and mothers, and it hasn't been found unconstitutional. I believe we need to take out doctors and mothers from both fetal homicide statutes to be clear that we just want to go after third parties that willfully kill a fetus, that do something to the mother willfully that ends in the death of her fetus. That is a homicide under our current
I'm guessing
current law.
this is such a morbid conversation, but I'm guessing that most fetal homicides are the result of an assault on the mother, not necessarily a direct assault on the baby. I don't know what the data is, but I would think that domestic violence issues and the like would result that way.
There are examples nationally of someone who did not want to procreate, and their girlfriend became pregnant, and they intentionally drugged. So that's what we're focused on.
So what's happened is this in this package of new legislation in Rhode Island, they are eliminating that, which then goes to whether the fetus and the mother are legislatively protected, meaning will the sentence for the assault or a homicide be counted for two people? And,
exactly.
And I watched a conversation between you and Bob Craven about that. He's suggesting that the statutes are plentiful for the life of the mother anyway. But you want a definition, I think understandably, that there's a second life here.
So our current statutory framework acknowledges a second life. Our United States Supreme Court case law acknowledges that there is legal status for a fetus. It specifically says the state has an interest in that potential life. And what this statute does is, because of the desire to eliminate legal status for the fetus, they are ridding us of the fetal homicide statute. And this was, I had a colloquy about 6 weeks ago during the abortion debate with, I think, Lynette Labinger from the ACLU, and I asked her, why are we doing this? And her response was essentially that we do not want a fetus to have legal status. So if you do something that results in the death of the fetus, and we pass this law, you can only be charged for your crime to the mother, which is an assault. Suppose she doesn't die, but the fetus does. The crime is to her. It's no longer for what you've done to the fetus. So it is eliminating the legal status for fetuses, which we have now. And we're talking about 8 months. 8 months in. And that is not a Roe v. Wade right. There is no right in Roe v. Wade for a third party to kill someone else's fetus. So the notion that all this does is merely codify Roe v. Wade, right on this argument alone, is disproved.
Yeah, I think you're right. And it's funny because yesterday on the radio we talked a lot about this notion of how many women decide to have an abortion in the third trimester. I wasn't so concerned about the addition of the word health for their pursuit, because the data is so low. It's 1% or less, and usually it has to do with a complication. Most pregnancies that get to a third term that are going to be terminated are being done for reasons of worry about quality of life and like. And we can have that argument, but there's no third trimester mill for abortion. But your points about what else is in this package, I think, explain the upset over the stretching, the expansion of the concept. And I think you make a very, very good point. We only have a minute. What do you think is going to happen tomorrow? Will that aspect dominate the conversation? Will the rank and file, do you think the Speaker's got the votes already? Do you think the Speaker's voting yes on this? I'm not so sure.
I don't think he's voting yes, but my experience is nothing comes to the floor unless the votes are there. I mean, this may be a special case. It may be a special case. You asked what's going to happen. I mean, there will be amendments to address these myriad of issues. And I especially hope on the fetal homicide issue, it's something we can fix. It really is a deep philosophical divide on the legal status issue. I don't understand why we would deny legal status. I just don't. I don't think society should be saying that a fetus is lesser than an animal, which if I kill, I can get in trouble for my act against that animal.
I think the argument is closed on that. There needs to be an amendment to the amendment to the amendment. Good thinking. Appreciate it, Minority Leader. Final word and we come back. Stay with us. You know, these additional conversations are important. They're not, the status of a fetus being denied in the horrid concept of murder or assault is just, I think, unexplainable. Maybe you can. Talk to me on the radio about it at 630-WPRO.com. I should say weekdays 3 to 6 on WPRO. This is going to be an interesting week. We're going to have an interesting day tomorrow, and we may have some Democratic response to this prior to that vote. We'll see. And what's the Speaker going to do? All these things are up in the air. Good night.